came across a court case that came across in Ontario on the 21st of January, and it's a fantastic document. So I sent an email out to all kinds of my homeopathic friends, and it got around. So what we're going to cover tonight, for at least part of the evening, is I'm going to go through this court ruling in detail, and for this quick case is about raw milk and Michael Schmidt in Ontario, if anybody's heard of that name. Now, the reason I invited a whole bunch of other people here is because this ruling, in my opinion, affects every aspect of our lives. There's no reason why you can't use the information that the judge put into this document in any other food, medicine, health, treatment industry out there. So it doesn't matter if you're into raw milk or not. I think this affects everybody. So I'm going to go through that in detail. But before I do that, there's a lot of people that don't really know me, so let me give you some background on where I come from and all this. My wife is a homeopath, Heilkunster homeopath, and she introduced me to this natural person stuff about 5 years ago. And so I've been studying this just about full time for the last 3 years. And about 2 years ago, I actually declared my sovereignty. So I sent letters to the Queen and the Pope and all the way up the food chain, essentially telling them that I no longer will accept benefits or privileges from the state. I essentially gave them my declaration that I will take full responsibility and accountability for my life. And so now I am getting up here and teaching people about the word game that they play, and the manipulation and the use of fear and intimidation to try to gain compliance from everybody. We just finished going through 8 modules here a few weeks ago. We actually recorded these. So if you missed them or you missed parts of them, come and see me afterwards. There's request forms in the back if you wanted to get the DVDs. It's a fantastic resource if you want to get the basics on how this all works. And then the mandate of this group is as a peer support group to help each other and learn from one another and hear how people's experiences are going in court and dealing with social services and maintenance enforcement and all that kind of crap. Okay, so
are you referring to the 10C?
That's right. Yeah. Okay. So when I go through this court case, I'm going to kind of expand a little bit on what the judge is saying based on my own understanding and experience. It's not just from the understanding that a typical civilian on the street would have, but I'm going to put in my own opinion as to what it really means based on research that I've done to try to unwind the words that they use too. Okay. If you want, I'll have the court case up here, but there's a bunch of copies in the back. They're $3 a copy if you want to go through it as we go through this, just to cover the photocopying costs. And you can take notes as we go through. I'm not going to go through the entire ruling, but I'm going to go through and highlight all the key aspects of this ruling so that we can really get an understanding what this judge is going to say. Okay. So my typical disclaimer, I'm not a lawyer or accountant or any of that kind of stuff, so I can't give legal advice. I won't give legal advice. And I ask that you draw your own opinions and your own conclusions based on what we're going to cover here tonight. That's completely your responsibility. Okay. Now, to put this into context, I thought I would go through and actually highlight a few key aspects that it's important. First off, the Queen's Oath. Okay, because if you take a look at the front page of this ruling, the ruling is Regina versus Michael Schmidt. Okay, well, the word Regina is Latin for Queen. Okay, so let's take a look at the Queen's Oath. And this isn't her whole oath. This is just part of the oath that she took while she was being coronated in '53. She said, the Archbishop, was it the Archbishop that said?
Archbishop of Canterbury?
Yeah. He said, will you solemnly promise and swear to govern the peoples, okay, I have those words underlined, of the United Kingdom of Great Britain and Northern Ireland, Canada, Australia, New Zealand, and the Union of South Africa, Pakistan, etc., etc., of your possessions and other territories to any of them belonging or pertaining according to their respective laws and customs. Okay? She said she would. So she agreed to govern the peoples of Canada. Okay? Definition of govern. Okay? This is from the online etymology dictionary. So this is the actual root of the word govern. Comes from the Old French to direct, rule, or guide. Okay, so she agreed to rule or guide us. Now, if I take a look at the Canadian Law Dictionary, okay, just a few books that I use through my research. Canadian Law Dictionary is one. Black's Law Dictionary is another. Bible's a third. So in this one, definition of Governor General. Okay, everybody's familiar with Governor General of Canada. Okay, Queen's representative. Definition in this book defines the Governor General as the head of state in Canada, the personal representative of the Queen. He or she holds in all essential respects the same position in relation to the administration of public affairs. Okay, I underline public because this is really, really important when we start going through this document. It doesn't say private affairs, it just says public affairs. Okay, in Canada as is held by the Queen in Great Britain. Okay, so we're going to be talking about public and private a lot tonight. Okay. Now, for those of you who attended my lectures series, I grabbed this off of Module 7. And what I was trying to get at with this screenshot is that when we're born, our parents raise us, and their mandate is essentially to try to raise us so that we become physically, mentally, and emotionally mature. Okay? But when we grow up, they use privileges and benefits to try to help us with that maturity process. Okay? So if somebody misbehaves, then you take a privilege away, kind of thing. Okay? But when we grow up and move away from home, we're supposed to be mature in all three of those levels, but a lot of us aren't. I know for myself, I wasn't even close to being emotionally mature when I moved away from home. And so what happens, we end up being in the care of another parent, and that being the state. Okay? And the state uses privileges and benefits to help us along the path as well. Okay? And privileges is like driver's licenses. Benefits are like employment insurance and pension and that kind of stuff. Jail is another privilege and a benefit. Okay? It may not seem that way, but people in jail are actually there voluntarily. You actually want to know the truth about it. Okay? But the whole process for me is to try to mature as an individual on all three of those levels so that I can become an independent adult that's self-governing, fully responsible, and fully accountable for everything in my life. Okay, absolutely everything. And when I can achieve that, then I have access to my rights and duties. Okay, with rights come duties. Okay, the Queen, for example, has a duty to look after her children because the Queen is the mom. Okay, and if we can build ourselves to become independent, then we can start looking at one another to build interdependent relationships, and that's where the true community comes in. That's where spiritual maturity starts to evolve, and social maturity. But I find that even in my life, that I was immature in a lot of aspects of my life until I started standing up and started taking full responsibility and accountability for my life. And to this day, I'm still not free of my dependency on some of the items from the state, but it's a process. Okay? And I bring this all up because the Queen, like I said, is the mother, and she swore an oath to govern the people of Canada in the public. Okay. So again, for those that came to my lectures, we have the private side and we have the public side. And on the public side, we have this whole entire bureaucratic structure that the Queen uses to govern her people. Okay? It's called the Lieutenant Governor. Okay, we have the Queen up here, and then we have the Lieutenant Governor. We have her Supreme Court, her military, her Parliament, Office of the Public Guardian, and the Lieutenant Governors. Okay? And then under that is the whole entire court structure, all the military, police forces, all that kind of stuff to help govern her people. Okay? And the straw man, or the corporations that I was talking about at the introduction, is all these little documents that are tied to each one of us that we applied for voluntarily. Okay? Now, I'm going to draw a big line down the middle here. On the private side, now that I've declared my sovereignty, is me as a man. Okay? And I chose to have one master in my life, and that's the Creator, God. Whereas all these people down here are dependent on this structure, and they have many, many masters. Okay? Everybody follow me so far? Okay.
Yes, Master.
Okay, so let's get into the court case. Okay, so like I said, the court case was between Regina and Michael Schmidt. Okay, so between the Queen and Michael Schmidt. Okay? And Regina is Latin for the Queen. Now, with this document, each paragraph is actually numbered. So for those of you that actually have copies, you'll see a number at the beginning of each paragraph. I'm not going to go through this whole document, so what I'm going to do is I'm going to refer to a paragraph, so we may be doing some skipping as we go along here. I'll try to keep this screen up to date so that those that don't have copies can actually follow along on the screen. Okay? So I'm going to go to paragraph 1. Okay, paragraph 1. The defendant is Michael Schmidt, a dairy farmer who carries on business as such in Durham, Ontario, under the name of Glen Colton Farms, which is registered as a sole proprietorship under the Business Names Act. At any one time, he has about 30 cows on his farm. Okay? So, my experience with all of this is that he has a sole proprietorship, which is that corporation that's within the constructs of Canada, that pyramid on the public side, okay? Because he was registered under the Business Names Act. All acts govern the public side, as we're going to find out here tonight, okay? So I know that that's public, okay? Paragraph 3, the products are sold by the defendant from a farm store which is located on the farm. In addition, the defendant owns a bus which he converted from a school bus into a bus for the display and sale of his farm products. And he actually drives the bus once a week to a local town to sell his products. Okay? Now I just covered that just to give you guys a little bit of basis on what the case is about and what Michael Schmidt was doing. Okay? How many here are actually familiar with the case? A few people? Okay. Michael Schmidt has actually been in court a few times over the last 10 years or so. He's been fighting, or trying to, I shouldn't say fighting, trying to change the legislation to allow for the sale of raw milk. Paragraph 8 on page 4. Michael Schmidt is the Canadian crusader for the introduction of legislation legalizing the sale and distribution of raw milk. However, the power of legislative adjustment is vested in the legislature. It is beyond the judicial authority of this court. Okay? So remember, this is the judge's ruling. So the judge essentially said, in order to change the legislation, only the legislatures can do that. He doesn't have the authority to do that. Okay? The legislation continues to be an integral part of our law. Okay? For those that didn't catch my modules, when you take a look at this pyramid here, okay, legislation and regulations govern this. That's their law. That legislation and regulations is actually the box that the Queen's servants are supposed to operate under, okay? To confine their rights and their duties for their jobs, okay? That's their law, and the judge falls into that category. That's why he says our law. What's my law? This is my law. Okay, this is the law form I chose to follow. Okay, you actually have a choice on which law form you can follow.
Is that the Ten Commandments, your law?
Pardon?
Your law is the Ten Commandments and all that.
Matthew 22, love the Lord your God with all your heart, all your soul, and all your mind, and love your neighbor as yourself. Okay. If you follow that, then you follow the Ten Commandments as well too, right? Okay, paragraph 12. Two internationally renowned expert witnesses gave strong supporting evidence for each side of the debate. The defendant's experts testified that unpasteurized milk is perfectly safe and healthy. On the other hand, the Crown's expert witness testified that such milk is a health hazard. I am convinced that if I had allowed 22 expert witnesses on each side, the result would have been the same, a draw, as far as the court is concerned. Okay? But not only is it beyond my jurisdiction to declare a winner, it is not the determination of this issue which is the task of this court. Okay? The judge admitted that it's not his job to determine whether milk is safe to drink or not, or I should say raw milk is safe to drink or not. Okay? That's outside the privy of the jurisdiction of this court. Okay? 13. The ultimate issue for this court is to determine whether the defendant broke the law. Which law is he talking about?
Their law.
Their law, right? And if so, to what extent he should be punished under the punitive segments of the legislation concerned. Okay? That's what this is all about. Chapter 17. Okay. Classification of charges. Now, the judge actually goes through the different types, the three different types of charges that he could possibly look at through this case. And I think it's important that we understand what they mean, okay? 17A, mens rea offenses in which the Crown must prove the actus reus as well as some positive state of mind which as intent, knowledge, or recklessness. Now, mens rea is defined as a guilty mind. So essentially, you need a guilty act with a guilty mind to have charges under point A. Okay? Point B, strict liability offenses in which the doing of the prohibited act, prima facie, which is a fact presumed to be true unless disproved by contrary evidence. What we're going to find out tonight is that there's a lot of assumptions and presumptions taking place. The courts and the government and the Queen assume a lot. And it's up to us to rebut those presumptions. Okay? So, prima facie imports the offense, leaving it up to the accused to avoid liability by establishing that he took all reasonable care. Okay? Also known as due diligence. Okay? You're going to hear that word tonight too. And then C is absolute liability offenses where it is not open to the accused to exculpate himself by showing that he was free of fault. That one means it doesn't matter what he says or does, he's guilty. Okay. Now, what the judge found is that in this case met the conditions of strict liability. So he essentially put the burden on the defendant, Michael Schmidt, to prove that he took all reasonable care to ensure that he was not doing a prohibited act. Okay, so the burden of proof now fell on Michael Schmidt to defend himself rather than the Crown to prove their case. (23) The descriptions of the offenses with which the defendant is charged do not contain any language importing a positive state of mind, such as intent, knowledge, or recklessness. Consequently, I'm satisfied that none of the offenses is a mens rea offense. So what he's saying there is he felt that with all the testimony that he heard, Michael Schmidt wasn't doing it to try to get away with something or intending to hurt anybody. Okay, that would have proven that he did it with a guilty mind, and that would have fit that first mens rea criteria. Okay. (25) Since all 19 charges are strictly liability offenses, the Crown is required to prove the actus reus of each offense beyond a reasonable doubt. Okay, what's that? Okay, actus reus, loosely, the criminal act, more properly, the guilty act or deed of crime. Every criminal offense has two elements: the physical actus reus and the mental mens rea. Okay, so essentially, guilty act with a guilty mind. Okay? If the Crown is able to do so, then in accordance with the direction of the Supreme Court of Canada, we're going to hear a lot of Supreme Court rulings tonight. In order to escape conviction, the onus devolves upon the defendant to satisfy the court on a balance of probabilities, either that he had an honest but mistaken belief in facts, which, if true, would render the act innocent, or that he exercised all reasonable care as to avoid committing the offenses. Okay? The Supreme Court of Canada explained in the Sault Ste. Marie decision with respect to the application of due diligence in the following words. Okay? The Supreme Court said that this is what due diligence is. Under the approach adopted by the court, the accused, in fact, has both the opportunity to prove due diligence and the burden of doing so. Okay? It's not up to the Crown to prove that the individual did whatever they could. The defendant is the one that has to prove that he did everything that he could. Okay? The burden is up to the individual. An objective standard is applied under which the conduct of the accused is assessed against that of a reasonable person in similar circumstances. So if they took a look at the case and another reasonable person made the same efforts, then that would satisfy due diligence. But if the individual didn't meet what a reasonable person would do, then that wouldn't have classified due diligence. Okay? In my opinion, that's quite subjective. How do you make a determination of what a reasonable person would do or not? I guess that's why we have judges. I don't know.
Theoretically.
Okay, theoretically. 29. Okay. Now, there's a statement of agreed facts. What happened in this case, I'm not exactly sure how they came up with these agreed facts, but the agreed facts is essentially an agreement between the defendant and the Crown as to some of the facts that they both agreed on, and the judge actually listed them. Okay. Point number 1, the defendant is not a corporation. Okay. Most people, when they go to court, because they don't know who they are, they go to court as a corporation. It's called a corporation sole. The judge asks you for your name. If you agree to be that name, you've agreed to be the corporation that he's looking at. So you essentially wrap a dead corporation around you to become one, and that's called a corporation sole. Okay? A corporation sole is the merging of a man and a corporation so that you can't tell the difference between the two. And that's what most people end up doing when they go to court. Okay? Michael Schmidt, I'm not sure, I haven't seen the transcripts of the actual court case, but he managed to get himself there as a man and not be the corporation.
Is that unusual?
Very unusual, yeah. I was very surprised to see that this fact was entered into the records that he's not a corporation. And then they go through a number of other points in there, but the important point there is that first one. He's not a corporation. So the man was actually the one on trial here, not the corporation. Okay, we're going to skip to 41.
Well, does that essentially mean that the Crown is in a position where it has to bring up an injured party? It's essentially
Well-
that then we're looking at a common law jurisdiction.
Well, there was no injured party in this case, though.
Yeah.
They didn't highlight any injured party.
That's what I'm saying.
So what happened? In my opinion, what happened is they got an agreement from him to have the court have jurisdiction over him in this case. Okay, and because there was no injured party, they didn't have technically the four legs on that table to hold a subject matter court. Yes.
Yeah, but they did that by having him commit himself to being a defendant.
Correct. Yeah, they got his permission to have jurisdiction over him.
Is that what, under 5 there? 43.
Under.
It says, I hereby require you to cease manufacturing, processing, preparation, storage, handling, display of milk.
Sorry, what paragraph are you on?
Oh, wait a minute. That was page 8, sorry. Yeah, page 8, under 5.
Page 8.
So
That was an agreed fact there. Essentially, they agreed that the health inspector sent him a cease and desist order, and he and the inspector or the Crown agreed that that actually took place.
So he
So
complied to that.
there's no dispute there. That's not in dispute. Okay. Michael Schmidt, based on my reading here, actually was trying to change the legislation and was not challenging the legislation itself, but trying to make the point that the legislation should be changed to allow for the sale of raw milk. He wasn't trying to have legislation thrown out or dismissed or any of that kind of stuff. He just wanted to change it. Okay. So he actually complied to or agreed that there was certain orders that was sent for a cease and desist. He agreed, but he didn't listen to them. Okay. So he wasn't disputing that he received them. Okay. 41. The essential elements of the charges under section 18.1 of the HPPA. The health, HPPA stands for health,
Health protection.
yeah, health protection, public act or something like that. It's essentially an Ontario piece of legislation to help protect the health of the people of Ontario. Okay. So essentially the charges was a person. Okay, what do we find out about a person? Okay. If you take a look, for those that haven't gone through this, the definition of a person includes a corporation. Okay, that means that a person is a corporation. Okay, a person is, I am not a person. Okay, a man is not a person. A person is actually a corporation or the legal representative of a corporation. Okay, so yeah, that's why we have to be very, very careful. I'm not a person, but I could be the legal representative of a person, which would then make me fall under the definition of a person. Okay. B, sells or offers for sale or delivers or distributes milk or cream that has not been pasteurized or sterilized in a plant that is licensed under the Milk Act. Okay, that's essentially the core aspects of the charges that were being laid against him. Okay. 43C, without a license from the director. Okay. As you have learned in my modules, who requires a license? Somebody looking for permission to do something. Who asks for permission?
Corporation.
Children ask for permission. Children ask for permission from the adult. Okay? When you apply or register, you are asking for permission from another authority.
Begging.
Okay? Everybody follow that? Okay. 47. Okay, what happened in this too is when they had a search warrant, and they went and they actually searched his property, seized some milk and product and that kind of stuff, and they actually questioned him. Okay, what did we learn about talking to police? Don't talk to police. Why?
It will be used against you.
Yeah, but not for you, right?
Never.
Okay, so never talk to the police, because it can be used against you, but it can never be used for you. If they try to use it for you, it's hearsay and it's inadmissible in court. Okay, what happened to him? He answered a whole bunch of questions, and guess what? It showed up in the judge's rulings. Okay, he's fortunate because it didn't crucify him in the case, but it's extremely dangerous to be testifying to police officers because that information can be used against you. Okay. So 47, the defendant admitted in the search warrant statement that he is not licensed by the director to operate a plant or distribute milk or milk products from a milk plant. Okay. And it actually shows some of the questions and answers that actually took place when the police were questioning him when they were executing the search warrant. Okay. If he would have taken my course, he would have known to not say anything. Okay. Near the bottom of page 12, I'm going to start right here. Question. Are you aware that it is illegal in Ontario to sell or distribute milk or milk products that have not been pasteurized? His answer was, oh yes, totally aware. He was very aware that the legislation said it was illegal. Okay. What is your understanding of how the cow share program would circumvent the milk laws? And his response is, it doesn't circumvent the laws. It gives the cow shareholders the same right as a farmer to drink their own milk fresh from the cow that they have a share in. Essentially, the premise of his defense was, if it's okay for a farmer to have a cow, milk the cow, and drink the raw milk, why isn't it okay for, say, you to buy a share in the cow, which you then own, okay, just like the farmer owned his own cow, and drink your milk? Okay, that's what he's essentially trying to get at. Okay. Makes sense to me too. Okay. Okay, we're going to skip to 64. That's on page 17. Is everybody there? Okay, 64. When asked how the cow share program constituted an exemption to his obligation to comply with the relevant legislation, he replied as follows: there is no exemption. It is simply a concept of a private contract between two people to attain rightfully a product which is not available normally to the public. Okay? Now we're getting into the difference between private and public. Okay? Where is the Queen's jurisdiction? Public. What's he trying to do? Private. Huge difference. Okay? Our power resides in the private. Okay? If we want to function in the public, whose authority do we fall under? The Queen's. Okay? Unless you specify otherwise. Okay, we'll get to that. 65. Both Mr. Ryan and the defendant were in agreement that there is no law which prohibits anyone from consuming raw milk and milk products. There is no law against it. Okay? And I'm not aware of any such legislation in the province of Ontario. Okay? Province of Ontario, uppercase P. Province of Ontario is a corporation. Okay? It's not an actual land. Okay? Ontario is the land. Province of Ontario is the corporation. Huge difference. Okay? Our governments are all corporations now. There is no legitimate form of governance on this land. Okay? Canada is just a corporation, just like the province of Ontario, just like the province of Alberta. It's all just corporations. It's all commercial now. Paragraph 75. I'm just going to read the bottom sentence here. In my view, it strains common sense that the defendant would sabotage his entire cow share program by selling small quantities of cheese for a total of $6.40 to someone who is not a member. The issue was that the individual that was trying to infiltrate his cow share program and buy stuff from him was actually an investigator, and she claimed that he sold her some cheese. And for the amount of effort and energy that he put into trying to protect his cow share program, the judge saw the conflicting evidence and ruled for him, because he felt that, you know, this guy has put so much time and effort into doing this, it doesn't make sense that he would sabotage it all for a sale of $6. Okay. In my opinion, this judge was
Own a share.
This judge spent a tremendous amount of time and effort and research to write this document, and I'm extremely impressed with the amount of elegance and how articulate he was with his responses and his thoughts on this whole process. I've never seen a ruling written this way before. So, 79.
It's a high profile case that makes them up their game.
Well, and I kind of wonder if there was some political pressure in the background to make sure that he made sure that this document was rock solid, because you know, I can see the Crown trying to appeal this, but I can't really see how they can actually do that. This case may still go to the Supreme Court, who knows, but he used so much rulings from the Supreme Court that I doubt if it's going to go anywhere. Okay. This judge also talked about statutory interpretation. Okay, I actually talk about it in my modules, how to interpret statutes. Okay, but the judge has some really good points here that he wanted to cover as well. Number 79. To resolve the issues which I have described requires an in-depth investigative examination of the complexities of statutory interpretation. In a nutshell, the prosecution argues that the prohibitions in the legislation governs all members of the public. Okay. The defendant, on the other hand, offers that such prohibited legislation does not apply to a specific group of people who are members of a select program, namely the cow share program created by the defendant, which is private. Right? Number 81, if the interpretation of legislation was such a simple task, why have so many books been written on the subject? Okay, he's saying that this is extremely complex to try to interpret legislation. Okay, and he actually lists a book here. So we finally have a name here of a book that we can actually read. It's called Dreger on the Constitution, Construction of Statutes.
Yeah.
Okay. So if you want to learn more about statute interpretation, that's the authority on how to do that. Okay. Indeed, the Interpretation Act of Canada states, okay, as you learned in my modules, the Interpretation Act is part of the acts that you need in order to deconstruct legislation. Okay. Section 10, the law shall be considered as always speaking, and where a matter or thing is expressed in the present tense, it shall be applied to the circumstances as they arise, so that effect may be given to the enactment according to its true spirit, intent, and meaning. Okay, so he's actually going to start talking about what the true intent of the act was that he was charged under. Okay, and if the charges don't match what the true intent was, then they're out of there. Okay. Furthermore, in section 12, every enactment is deemed remedial and shall be given such fair, large, and liberal construction and interpretation as best ensures the attainment of its objectives. Okay. What does remedial mean? Number 89, Black's Law Dictionary, okay? He's referring to this. Okay? The word remedial, defined as intended to correct, remove, or lessen a wrong, fault, or defect. Okay, so the act has to have a broad interpretation to ensure that if there's a intent there that's incorrect, that it's there to make sure that it is correct, to correct a wrong. Okay. 92. The Court of Appeal found that since one of the purposes of the legislation in question was public safety, okay, let's remember that term, public safety. Okay, not private safety, but public safety. Okay? The context, and more importantly, its purpose, points strongly to a broader interpretation. Okay. 93, Section 12 of the Interpretation Act. A purposeful interpretation often requires a restrictive interpretation, one in which the scope of the general language is narrowed so as to exclude applications that are outside the purpose. So what he's saying there is if the act has a specific purpose, then the legislation itself must be very, very specific so that it only works towards that purpose and that purpose only. You can't all of a sudden broaden the purpose of the legislation to include things outside of the purpose of the legislation. Okay. 94. My view is that the sections in issue under HPPA and the Milk Act constitute legislation which is drafted in general terms so that the court must adopt a restrictive interpretation, one in which the scope of the general language is narrowed so as to exclude applications that are outside the purpose. Okay, so the court took a look at this act and said, because it's so broad, I have to focus in and exclude everything else and take a look at this very, very specifically. Okay. Question before me, number 95. The question before me may be simply expressed as follows. If the purpose of the HPPA and the Milk Act is primary public safety, does the legislation apply to a structured group of private people? Very good question. Such as the members of the defendant's cow share program, who may wish to become involved in activity which in itself is not unlawful. It's kind of a double negative, okay? So it actually in actions that are lawful, okay? So that public protection of such people is not required, and therefore the legislation concerned is not applicable to them. Okay, so if they're involved in lawful activities, then why would the legislation apply? Pardon?
For lawyers, it's necessary to put in negative form because that's the only way they understand it. Are you lawyers?
Any lawyers here? No. 102. Statutory interpretation is founded on the assumption that legislatures are rational agents. Okay, there's another assumption. And he admitted it. It's founded on the assumption that they're rational. Well, I think a lot of us would argue that they're probably irrational now. So if you wanted to argue that point, you could probably get a lot of legislation thrown out. Okay? All you're doing is you're questioning the assumptions that they make. Our legislature, the judges, lawyers, the Queen, they make a lot of assumptions, and unless we challenge those assumptions, they will continue assuming. Okay? He just admitted that this is another assumption that they make. Has anybody challenged this assumption? It might be an interesting challenge to make. Okay? They enact legislation to achieve a particular mix of purposes, and each provision in the act or regulation contributes to realizing those purposes in a specific way. Okay? .106. Okay, I'm doing point 11 right here. The objectives of the Provincial Act are carried out by the Ontario Farm Products Marketing Commission and the Dairy Farmers of Ontario. The body is appointed by the Lieutenant Governor and Council. Okay, so we have the Governor General, who gives some of her authority to the Lieutenant Governor. The Lieutenant Governor has his own council, and that council is then appointing authority down to another body. Has any of that authority been voted on or approved by the public or by voters?
No, it's appointed.
Whose authority is that coming from? Queen. Okay, it's not your authority, it's the Queen's authority. Which is empowered to make regulations with respect to the production and marketing of milk in Ontario. Okay, why does the Queen have that kind of authority? Because she's responsible for the public. Okay. It is also authorized to delegate its power to make regulations to a marketing board like the DFO, the Dairy Farmers of Ontario, including regulations requiring that milk be marketed by, from, or through the marketing board. Okay, can they change regulations whenever they want? Yeah.
Does that paragraph seem self-serving to those involved, or is it just me?
Well,
It's just,
well, they have a duty, right?
Right.
They have a duty
To
to
make
the
money.
public. Well, it could be easily corrupted to make money. Okay.
That's outreach.
But when you bring it down to the root, they're essentially responsible for protecting the public. If it's been corrupted along the way, then maybe it's our duty to challenge that. But this is where I'm trying to explain where they're coming from, right? Okay. Penalty considerations, 107. So under the charges that he was charged with, there was, I think, 16 charges. And what the judge did is he actually took a look at the penalties and actually considered whether the penalties actually fit the crime kind of thing, right? So he wrote here, this is what the act says. Every person who is, what's a person? Corporation, okay? Who is guilty of an offense under this act is liable on conviction to a fine of not more than $5,000 for every day or part of a day on which the offense occurs or continues. Well, this has been going on for months and months, or years. 110. Okay, the judge actually said, I do not intend to do the math. However, it is clear that the totality of the potential fines would be astronomical. As such, when I consider these penal consequences in conjunction with the remainder of the findings herein, I cannot accept that the legislature ever intended that a person who is not putting the general public at risk and who is functioning at all intents and purposes within the parameters of the law should face such an enormous punishment. It would have been worth millions and millions of dollars. And he couldn't justify his actions. The actions didn't fit the penal punishment that was in the act.
Is it common for a judge to have this much input into a case?
No.
Not at all.
No. Like I
It's
said,
like he's defending.
this is extremely detailed and very articulate and complete.
Now, did you say this is went into common law court, or was it in?
No, so this is provincial court, Ontario Provincial Court.
So, how does that work with Admiralty and common law?
He's in their court, so it doesn't matter whether it's Admiralty or not. They got jurisdiction from him to have this in their court, in their provincial court.
Because this judge is acting like a lawyer.
This judge is acting like a judge.
He may be acting this way because at the very first sentence said that I do recognize you as a person, not a corporation.
He didn't say that. It said that he is not a corporation. They didn't recognize him as a person.
Right,
Okay.
but that's what I meant to say,
Yeah.
okay?
Yeah.
That's what it is.
Okay. 114. Succinctly put, the scheme of the act. Okay, well, when I read that, I'm kind of thinking, okay, well, scheme is not a very good word here. Okay. But I then figured out, if I put this word into context and how articulate this judge is, maybe I should look up the word scheme to see what he really meant. Okay? So I looked up the word, and a systematic plan or arrangement for achieving a particular object or effect. Okay, it's not scheming to try to bully somebody into something or anything like that. Okay, so yeah, they weren't scheming, but it is a scheme, and a scheme is something that's very systematic. Okay, so it's really important that we take a look at the words in context, not assume like what they do, but actually take a look at what the words actually mean in context. Okay. So the scheme of the act essentially embodies a process for the control of the production and marketing of milk and milk products in the province of Ontario. Okay. At the bottom it says, which states under the heading rebuttable presumption. Okay, the act actually has a rebuttable presumption heading in the act. Okay, now we're getting into what I've been talking about, is rebutting their presumptions. They presume and assume a lot of things, and it's our burden to rebut them. If we don't, they will continue using those assumptions against us. Okay. Is that what you're trying to tell me? In any prosecution for an offense under this act, the act or omission of an act in respect to which the prosecution was instituted shall be deemed to relate to the marketing within Ontario. Okay? The judge underlined should be deemed to relate to the marketing within Ontario. This is very important. Okay? Because now he's starting to take a look at the word marketing. You have to know what that word means in order to see if it actually applies to you. Okay? 115. The presumption in section 25 clearly places the onus on the defendant in this case to rebut that presumption by providing to the court on a balance of probabilities that the cow share program as it was established and is being run by him does not constitute marketing within Ontario. Okay? The burden is on him to prove that, not the Crown. Okay? 116, marketing includes, okay, what did we learn about the word includes?
It only means whatever's after.
Yeah. The inclusion of one is the exclusion of all others. Okay, so when you see the word includes, what you're doing is you're defining the word marketing, excluding everything else. This is what marketing is. Okay, and he gets to the point of commercialization, commercializer, commercialize. Okay, those three words. Now we're into commerce. Okay, we talk about commerce a lot in this group too. Okay, these are commercial activities. If you're in a commercial activity, you're marketing. Okay? 119B. The specific inclusion at the end of the definition of marketing of commercialization, commercializer, and commercialize makes it plain and obvious that commercial marketing is its broadest sense in which is meant by the term marketing. Okay? Commercial marketing. Okay? 119C, utilizing the Latin interpretive guide, inclusio unius est inclusio alterius. Okay? What does that mean? Okay, that's Latin for the inclusion of one is the exclusion of another. Okay, we learned that in Module 1, and this has just been confirmed by the judge in this case. Okay, this is part of how to interpret statutes. Okay, when they use the word includes, excluding everything else, this is what the word means. Same goes with the definition of the word person. Person includes a corporation. So excluding everything else, a person is a corporation or the legal representative. Okay, everybody follow that? So the judge goes on to say the term marketing as used by the legislature means commercial marketing. Within the general public. Okay. And excludes a small group of people who have come together by private agreement.
Alright.
Oh, you just wait, it gets even better. Okay, but that's huge. Okay, if you have a private agreement and you're communicating to one another regarding product or price or any of that kind of stuff, are you engaged in commercial marketing?
No.
No. Okay. 121. Thus, my interpretation is that the legislation refers to the public at large and does not include the defendant's dairy operation as it is currently being conducted, where sales of the defendant's dairy products are absolutely restricted to members of his cow share program. Okay.
I have a question about this.
Yes.
When you're making an agreement with somebody, and that's the handshake, or just like the old-fashioned handshake, right?
Yep.
Speak up.
When you're making an agreement with someone, and you have a handshake, like, what is an agreement between private people, me and you?
He'll actually outline what he's looking for in a private agreement. We'll get to it.
So this is like real.
Yeah, he actually outlines what you need, what conditions need to be met in order for that to be a private agreement. If you don't meet those conditions, then it's public. And then it falls underneath the legislation. Okay? So we'll get there. 122. Furthermore, notwithstanding the broad definitions of plant and distributor, I find that in all circumstances, taken into account the structure and conduct of his entire dairy operation, the defendant did not require a license from the director to operate his dairy product enterprise as he does, nor did he, by doing so, carry on business as a distributor of fluid milk products without a license. Okay? Because he met those terms and conditions, he didn't meet the definitions as outlined in the Act. Therefore, he found the defendant not guilty. 126. Of particular significance are the terms public and people of Ontario. Okay, here's where we start to define what the public actually means. Okay, those terms must surely be understood contextually as relating to the public at large. Okay, so that the intrinsic aim of this legislation is the protection of the public at large. Okay. Does this legislation then also govern those members of the public who do not believe that they require such protection? If you don't believe you need the protection, are you forced to accept the protection from the Crown? Don't we have free will? Don't we get a choice in whether we accept terms and conditions of contracts or not? Absolutely. Okay, and this ruling proves that we do. Okay. In other words, 127, in other words, are the cowshare members bound to accept the protection offered to the general public in the legislation, or are they permitted to reject the protection offered and assume any risks which they may be involved?
Absolutely.
Absolutely. Okay. 128, it is noteworthy that the first definition of the word public in the Concise Oxford Dictionary, 1990, is, quote, of or concerning the people as a whole, close quote. Okay, so when they use the word public, they mean everybody, not a group. Are we the public here? No, this is just a small group. So when they use the word public, that means everybody. As soon as you start isolating a group, all of a sudden you're not talking about the public anymore. Okay. 130. Toronto versus Original Playhouse Cafe. Okay. This is a court case that went all the way up to the Supreme Court. And essentially what it was is this guy had a cafe. I think this is regarding smoking. Yeah, no smoking bylaw, okay? In broad terms, when an invitation is addressed or is aimed at the public in general with no restriction, okay, as to who can attend, then all members of the public have that expressed or implied right of access. So if you don't do any restrictions, then it's implied that anybody can come. Okay, and when that happens, then you're dealing with the public. Okay. On the other hand, when invitations are limited or given to specific persons, then those invitations would not be made to the public in general. Hence, depending on the context, the type of event, the type of premises, and where the public is not ordinarily invited or permitted access to an event, then the function is normally a private function. And the premises are not a public place for the purposes of the no smoking bylaw. Yes?
So, if you wanted to have, you wanted to smoke, you could say you're having a smoking group and write up invitations to attend, say, a Thursday night smoking group.
Yeah.
And so you're still doing it on the private and
Yeah.
to hell with all this other stuff.
And we'll get to the point here in a bit here that you can even do that in a commercial space.
Go on.
Okay? So if you own a restaurant, you can hand out invitations so that smokers, and only the smokers got the invitations, and only people holding invitations can get through the door.
Or a cigarette.
You would obviously need a cigarette if you're going to smoke, but because of the invitations, because of the control of people going in, that's private.
That's private.
Yes.
Oh, here's a good one. I was in Dallas, Texas. We went into the bar to have a drink, and it was a dry area. In other words, they banned all liquor. But there's a bar there. So the bartender comes out, he puts a piece of paper in front of us and says, fill out this form. And so we filled out the form. You've just joined a private group, a private membership in a private club.
Yeah.
Now I can serve you drinks.
Yeah, well actually, he actually talks about that. He actually concludes that that's still public because anybody can still walk in and fill in the form. Okay, we'll get to that in a second. Okay. 131. This is an Ontario Supreme Court case, paragraph 17, right here. To be a private club under the code, the club must operate solely for the benefit and pleasure of its members and direct its publicity and advertisement to its members. So you can't just advertise in the newspaper. Okay, your advertising can only go to members. Okay. In this regard, there was no extensive evidence presented that publicity and advertisements were directed to the public at large, leading to the suggestion that the club was not operating solely for the benefit of its members. Okay. The point I'm trying to get here is that he's dragging in court cases that apply to smoking clubs, and we're going to get to one where there's actually a sex club. It doesn't matter what the context is in regards to whether they're selling milk or anything like that. We're talking about public health. Okay? Which means this applies whether you're selling raw milk or colloidal silver or health food products or homeopathics or any of that kind of stuff. Okay? You guys understand how important this ruling is to all of this stuff? Okay? 135. Okay, here's an example similar to, sorry, what was your name again? That mentioned the bar?
Armin.
Okay, here's the case that I was referring to that kind of matched what you were getting at. Okay?
Rob, can you just put what you're showing at the top of the screen?
Oh, sure, yeah.
Thanks.
Does that help?
Yes.
Okay. He wrote, in this particular case, okay, membership was solicited by recruiters who approached members of the public who were smokers. Okay, application forms were provided to interested people and were also available at the door. See a problem there? Okay. Members were required to sign the form, agree to pay $4 a month, and undertake to comply with certain rules. That's not that far off from the bar scenario that he just shared. Okay. There was an electric open sign on the window. Okay, that's not good. Okay, because that's an invitation to the public, isn't it? Okay. There were no signs prohibiting entry. Okay. Although one sign advised patrons who were sensitive to secondhand smoke not to enter. Okay, the court ruled that they didn't meet the criteria for a private club, which meant they were public, which meant that the legislation applied to them. Okay. 137. The overall purpose of the Smoke-Free Ontario Act is to protect vulnerable, non-smoking members of the public. Okay, now we're getting into this word vulnerable. Okay? They assume that everybody in the public is vulnerable, unless you rebut that presumption. Okay, so unless you rebut it, you're vulnerable in the public.
To traffic tickets.
To everything. They assume that you're incapable of conducting your own affairs, you're incapable of protecting yourself, you're incapable of doing your own due diligence. So they have to look after you like a 5-year-old. Okay? You see the child-parent relationship going on here again? Right?
But they limit in their own house, like how much measure of force we can bring to the fight, should someone be in your house.
Well, that's different. That's private. Once you're in your house, you're private. Unless you haven't done your due diligence and you've brought everything in your private life into the public. Okay? What do we do when we do that? We register our vehicles, we register our property, we register our kids, we apply for building permits and all this kind of stuff. When you apply for all that kind of stuff, what are you doing? You're taking all your private stuff and putting it into the public. Okay? That's why I don't have any of that stuff anymore. I want to try to bring everything back into the private, because that's where my power is.
So if someone enters your house uninvited, and
they're in big trouble.
And you shoot them, that's okay. But
Well,
if they
no,
come
I can't use excessive force.
But if they come into my house, I have all this public in my house, so now.
Well, again, we have to rebut their presumption and do our due diligence to demonstrate to them that you are a private man. That's why I declared sovereignty. I told them that all my contracts with the state is canceled. I've given them a claim of right to tell them that I'm rebutting any presumptions that they make, and if they want to prove otherwise, they have to rebut that presumption with me. Okay? And all my letters that I wrote, I set up the boundaries for how they're going to deal with me, including if they contact me now without my permission, it's going to cost them 1,000 ounces of silver per piece of paper. Or if they pull me over on the side of the road, it's going to cost them 50 ounces of silver per minute of detention. When you get pulled over on the side of the road, you're being detained. But the problem is that most people drive with a driver's license, which is a public instrument, which puts you into the public. But you still have a right to travel privately using the public right-of-way. But unless you rebut that presumption and write the letters to the state, they'll presume that you're in the public.
This legislation, or this case is huge.
This case is huge. Yeah.
Wow.
That's why I was like giddy with excitement when I was reading it. Like, this is huge. This is judicial support for everything I've been trying to teach people over the last year and a half. Those that took my course, would you agree that this is supporting everything I said?
Oh, yeah, absolutely.
This is part 9.
Yeah. Yeah, you better make a part 9.
That's what I called this PowerPoint presentation, Module 9.
Oh, good.
Because it's only in the provincial court, is it setting precedents? Or it only
Yeah,
sets
we're
precedents
in
when it
common
uses-
law, so we can use court cases from any common law jurisdiction
Oh.
to support your arguments in court. You can use.
I thought it had to be only in.
No, you can use court cases in Australia,
Oh.
Great Britain, United States, whatever. Right?
India, Ceylon.
In addition, that part about the Supreme Court rulings that he adds in here adds a huge weight to
Absolutely.
this, making it similar to.
Supreme Court ruling. Yeah. because he used so many Supreme Court's rulings to support his conclusions in this, it would be just about like the Supreme Court made the same ruling. Okay, so it'd be very hard, very difficult for somebody to appeal this case. Okay, Supreme Court rulings, paragraph 139. I'm just going to read off the last sentence here. Okay, there is no doubt. Remember, this is Supreme Court saying this. Okay, there is no doubt that regulatory offenses were originally and still are designed to protect those who are unable to protect themselves. And that's all that they're for. Now, how huge is that one sentence? That's monumental.
Huge because they presume everybody's unable.
Absolutely. But you have to rebut that presumption and say, you know what, I'm capable of looking after myself, thank you very much. Does that mean that if you get injured that you can go and sue them?
No.
No.
That means you're fully accountable.
You're right. That means you're self-governing, 100% responsible, 100% accountable for yourself. You can't blame anybody else. If you want to go around blaming people and suing people, then go around in the public as a vulnerable, but you're subject to the legislation. You can't have it both ways. Okay?
What number was that?
That was 139. 140. Again, the Supreme Court continued. At the same time, some conduct is prohibited, not because it is inherently wrongful, but because unregulated activity would result in dangerous conditions being imposed upon members of society, especially those who are particularly vulnerable. Okay? There are lots of things that we can do lawfully, but legislation makes them illegal to do them publicly because there's inherent risk. Well, everything in life is risk, has risk involved in it, right? We just have to take measures to mitigate risk. A responsible, accountable adult will mitigate risk.
I often hear the term lawful and legal. What is
Lawful are the things that we can do. Legal are the things that they pass legislation to tell us whether we can or cannot do. So when we're dealing with that pyramid, that's legal. A man standing out here in his private capacity is doing things lawfully. Okay, notice the difference? Okay. 141. In my view, again, this is the judge talking, those poignant statements from the Supreme Court beg the question, and this is the most fantastic question I have ever heard. If the ultimate purpose of regulatory legislation is to protect those who are unable to protect themselves, especially those who are particularly vulnerable, do those members of society who expressly waive the need for protection still need protection?
Wow, my God.
Isn't that a great question?
Yeah.
I don't want their protection.
It's the crux of the matter.
Okay? That's the whole point of this whole ruling, in my opinion. Okay? What is members of society? Well, a member is defined as one of the individuals to whom an organization or a deliberative assembly consists and who enjoys the full rights of participating in that organization. Does that mean that you have a choice to join or not? Yes. Okay, what's a society? A community of people. You can choose whether you're going to participate in that society or not. Which society is a good question? Law Society of Alberta? Law Society of Canada? That's what most people in the freedom industry are actually arguing that that whole pyramid is. They're talking about the Law Society of Canada. So if you don't join another society or you don't make your own group, they assume or presume that you're looking for protection from their law society. Related to this case at bar, there is another interesting term. I'm going to research that one. What does it mean to be at bar? Well, we're talking about the Bar Association, right?
And at law.
And at law is another term too, okay? If in consuming raw milk per se, the cow share members are not committing an unlawful act, are they committing an unlawful act?
No.
No, okay. And they wish to continue to do that within the parameters of the essentially private cow share program, why should they be forced to be bound by legislation which is intrinsically aimed at the vulnerable, those who need the protection? Okay. Now do you understand why this fits into just about every aspect of our life? This isn't about raw milk. Not even close. This is about how we govern ourselves and whether we're going to recognize the authority of the Queen to govern us if we're going to just walk through the public being irresponsible, or if we're actually going to start taking responsibility and accountability and govern ourselves. And if we're going to do that, there's certain criteria that we have to meet and make sure that we do our contracts properly.
We also owe Mr. Schmidt a favour for bringing this up and being prepared to fight it in this manner.
I'm sure that he'd be more than happy to hear from you guys. Okay.
And the judge.
Send him a group hug.
Well, by forcing the issue and having spent time in Ontario while this has been going on, it's quite a big issue out there. It's taken some mainstream media attention. So the judge was forced to be on his best behaviour and make a conclusive reading.
Yep.
Judgment. So we're lucky to have
How
it.
long has this been going on, this case?
I'm not sure. Does anybody know when
10
the?
years, a good 10 years.
That's what I mean.
Well, that was when. That's how long he's been fighting this whole milk issue. But when the actual charges were laid in this case,
It's in 2006.
Last spring.
October 2006.
2004 was the order stopped.
Okay. Yeah, the orders were in 2004, so it's been going on for like six years.
I don't know if it's possible or not, if a private person wanted to hire somebody to work for them privately, would they be subject to occupational health and safety?
That's a private. We've just been talking about that's a private contract.
It is.
Okay. So unless you go through the actual conditions of establishing that private contract, the legislation doesn't apply. If both parties agree to assume the risk. Okay, if somebody gets hurt, who's responsible? Them. Not the state.
Providing you're not contracting, say, like with a 15-year-old kid to do labor.
Yeah, well, 15-year-old kid can't enter into his own contracts. Okay.
That's what I'm saying.
Yeah.
You've got to be full disclosure.
Yeah.
So surely this goes right across the spectrum.
It applies to everything. It applies to all of our contracts that we have in our lives.
But what's the age of consent outside of their world?
In my opinion, in the private side,
Yes.
okay, there's a legal age of 18. What does that apply to? The public, right? But for my oldest boy, when he turns 18, I know for a fact that he's not going to be self-governing. Okay,
or else.
So, yeah. So you know, I may have to govern him for a while longer. But my 13-year-old right now, I highly suspect that he would be in a position where, you know, if he behaves himself properly and learns properly, he could be self-governing before he turns 18. Okay, but that's my duty and responsibility, is to train them and teach them so they can be self-governing, and it would be under my terms and conditions before I say, okay, you're old enough to be self-governing. I'm not going to depend on the state to make that determination.
So it should be up to the father.
That'll be your son.
Could I just add another answer to this gentleman too?
He didn't like
What is your first name again?
Let's just call myself Dale.
Oh, Dale. Oh, Dale, I'm a roofer.
Yeah.
And a lot of my roofing is by invitation. That's
Yeah.
what I'm getting out of
Oh.
the winnings out of here. Rob and I have talked this before.
Yeah.
You know, you go on the commercial side, most people, they tell you have to go get registered, be a corporation or limited or whatever. I've never done that. Most of my roofing's always been by invitation, and it's always a private agreement either between me and a roofing company or a customer or person. And so this is gonna be my saving grace. because that's what I wanna stay. I wanna stay in the private side and out of the corporate stuff. So you're a mechanical engineer, do you do subcontracting or whatever?
I wish I was a mechanical engineer.
Oh, someone else
That'd be
then.
good money.
No, what is it you do?
Quality control.
Okay.
Okay, let's keep going. Let's keep going. 143, okay? I find that the defendant's cow share program is a legitimate private enterprise which does not constitute marketing within Ontario. Okay. 145. These findings support the existence of a valid private agreement between the defendant and the cow share members in terms of which he is responsible for the upkeep of the cows and for the provision of milking for the membership. The responsibility of the members is to pay a fee for the upkeep of the cows, the production of the dairy products, and their delivery. Okay? Every contract requires consideration. Both parties have to bring something of value to the table. He brought value in regards to looking after and milking the cows. Their value that they brought to the table is paying him money for what he brought to the table. Okay? Without that equal consideration, this isn't a valid contract. Okay?
So according to this is all private, this is not taxable either.
That's absolutely. If it's private, does it fall within the scope of legislation? No.
It's private.
It's private. Okay, you can bring it into the public if you want, but that's why I talk about social insurance numbers. Okay, social insurance number is a federally incorporated corporation, okay, which is now in the public, and so if you are employed and working through that SIN number, that is a public activity, which is now taxable and subject to employment regulations and compensation regulations and all that kind of stuff. Okay, but if it's private, does legislation apply to a private contract? No.
So the social insurance number, I was just talking to the banks, sort of feeling them out a little bit, and they require social insurance number to open up a bank account.
No, they don't.
No, they
They
don't.
do,
They
but
don't.
opt to two separate banks.
No.
They ask
It's
for
optional.
No, if you're doing a sole proprietorship.
it, but yeah, for sole proprietorship they do, because that sole proprietorship is a corporation.
It's registered.
It's registered, okay? But you, the man, can get a bank account because you don't have a SIN number.
It has to be non-interest bearing. Right?
Well,
Yeah.
SIN number would refer to commercial
Interest
account.
on your absolutely tax.
Okay, let's keep going. Okay. Great thing about what this judge did is he also ruled on legislative harmonization. Okay, this is really cool too. Okay. 148. Okay, this is another Supreme Court ruling. Okay. There is no doubt that the principle that statutes dealing with similar subjects must be presumed to be coherent means that interpretations favoring harmony among statutes should prevail over discordant ones. Okay? How about Bill C6, people? Okay? They're trying to give the legislature authority and Health Canada and all that kind of stuff authority to come into your private home or business and confiscate materials and all that kind of stuff. Okay? Is that in harmony with all the other forms of legislation that deal with health? Absolutely not. So does that mean that Bill C6 would actually have authority?
No.
No, because it's not in harmony. Supreme Court ruled that. So if they try to pass Bill C6, we have a Supreme Court ruling here that says that that legislation is no good. $154. In the Smoke-Free Ontario Act, the government enacted legal restrictions relating to the sale of cigarettes and other tobacco products to the public and smoking in public places. I am of the view that in the case at bar, the defendant himself has established a self-imposed restriction on the sale of his dairy products so as to avoid the sale and consumption of his dairy products to and by the people of Ontario at large. Self-imposed restriction. That is an excellent example is somebody who is self-governing. Okay? When a teenager turns 18, what's a typical response? They go party and speed and they just go crazy because they don't know how to govern themselves. They don't know how to deal with this freedom that they have. Okay? But a self-governing, responsible adult would govern themselves and impose self-imposed restrictions. And the judge found that he had done that. 158. There is compelling evidence before me that the people who are permitted to buy the raw milk products from the defendant, 1, are fully informed of the fact that the milk is not pasteurized. Full disclosure. Okay? And are provided with a booklet explaining the farm practices and the respective responsibilities of the defendant and the cow share owners. Okay? So the Michael Schmidt provided full disclosure to the people so that they knew what they were buying, so that they can make an informed choice. 2, are given cow share membership cards in their own names. Identify who the members are. 3, purchase shares in the cows of their own free will. Nobody forced them to buy the cows. Okay, they chose for themselves. 4, pay an amount for the shares relative to the milking life of the cows. 5, consume the milk at their own risk. And 6, are fully aware that the milk is not freely available to the public at large. Making sure this is all private, right? In addition, it is essential to note that there is no evidence that anyone ever became ill as a result of the consumption of the defendant's milk products, so they couldn't prove they actually harmed anybody. Okay? If he harmed somebody, would that be a different charge?
Yeah.
Absolutely. Okay?
Even though they took it on their own free will?
Yeah. He still has a duty to make sure his milk is safe. Okay? 2, the tests conducted by the public health officials on the seized products revealed nothing more than that the milk was not pasteurized, which in of itself is deemed to be a risk to public health by virtue of the provisions of the Act. Okay? The Act defined that raw milk is a hazard. Despite that, he still found that it wasn't a hazard to the individuals who purchased shares because 1, there's nobody that got sick, and 2, they did it of their own private agreement, which means the Act doesn't apply. So he couldn't use the definition in the Act against him. Okay. 162. Okay. This case with Labay, is that how it's pronounced? Thank you. Okay. This particular case was in regards to a club owner who had memberships and went through a very specific interview process to allow membership into his sex club. And only people that were members could get through the door or guests. Okay? And so because of that agreement, the Supreme Court ruled that that was a private agreement, even though it was being held in a commercial space. Okay? Let me say that again. It was a private club held in a commercial space, and it was still deemed by the Supreme Court as being private.
So a private person can do business with a corporation?
In a corporate space.
Corporate.
Yeah.
You can actually have a contract with a corporation.
And it'd be private.
And it'll be called private.
If you follow the requirements that he had laid out to make sure that it remains private. But if that corporation is doing business with the public, then it's no longer private, is it? Okay.
What if it was doing business with the public on a different day? What if you had just say for example, you had one day you were doing business in a corporation, but the rest of the week,
if that one day only
private, it's
private
okay.
Contract with specific members, and you controlled access to the premises, and only members got in to facilitate that contract, it's still private. Doesn't matter what day of the week you're doing it, right? Okay. So 162, my understanding of the central principle of the majority of Labé is that the primary reason why the sexual activities in the club were not regarded as an affront to socially acceptable norms of decent behavior was that the people who were permitted to enter the club were paid up members who were entering voluntarily and were fully aware of the range of sexual activities occurring therein, removed from the glare of the public at large. Here's a point I'm trying to make. Okay? Legislation doesn't care about the morality of what we do. Okay? That's not their purpose. Their purpose is to ensure that the vulnerable are safe. Okay? So you can even do immoral acts in a public, immoral acts in a private contract and it still be legal. Okay? 164. Okay. It is clear that the HPPA simply creates a presumption. Okay, there's that word again. They presume that all unpasteurized dairy products constitute a health hazard to the people of Ontario. Only one person got that? The judge ruled that the HPPA simply created a presumption that raw milk is hazardous, just by defining it as so. Okay? The definition of health hazard under that act. 1, a condition of a premise. Okay? A substance, thing, plant, or animal other than man. Okay? Remember that word man. Or a solid, liquid, gas, or a combination of any of them that has or that is likely to have an adverse effect on the health of a person. What's a person? A corporation, or the legal representative of. Okay. What's a man?
So if I drop my birth certificate into a glass of unpasteurized milk.
No, if you take your glass of milk and stir it with your finger, then it can't harm your birth certificate.
Oh, okay.
169. Okay, I'm going to start from right here. From my own personal research, this judge did a lot of research in writing this document. I have good reason to believe that similar cow share programs are functioning lawfully, okay, there's that word lawfully, in large parts of the world, including the United States, Australia, British Columbia, Nova Scotia, Ontario, Great Britain, Germany, Finland, Sweden, and New Zealand. Okay? When a judge makes a ruling, they can't just take this one's particular case. They have to take a look at all other common law jurisdictions and what are other people doing out there. And he found that these cow share programs are happening all over the world. Okay? That's what common law is all about, judicial precedent. So if there's a precedent out there that people are doing this in other jurisdictions, then that has to take precedent over what he's trying to rule on as well. Uh, 177. In that case, he's referring to a case in BC. In that case, ownership of the cows remained vested in the defendant. In my view, the establishment of the cow share program creates a sharing of ownership of the cows amongst the members, which is quite different from the leasing program. Okay, what he's trying to get at is actually owning the cow is very different than leasing the cow. Okay, lease, what is a lease?
Rent.
It's a commercial activity. Okay, that's very different than you actually owning it. Okay, does the legislation apply if you're in a commercial activity? Yeah, it falls under marketing, doesn't it? It would fall under the definition of marketing. Okay, so be very careful between leasing and owning, because that's the difference between private and public. 181. The milk and milk products are reserved for sale and distributed only to specific members of the public, namely those who are knowledgeable, which means not vulnerable. Okay? paid up and properly informed members of the cow share program, especially created by the defendant, so as to make these products available for certain members of the public who wish to obtain them. That was 181. Okay. 185. Okay. Is just the second last paragraph. He wanted to make it very, very clear that his ruling does not in no way stand for the proposition that henceforth it is legal to market unpasteurized milk, or that it dissolves the act in any way. He wanted to make it very, very clear that his ruling doesn't make the act unconstitutional or anything like that. Okay, so those acts are still in place for the public. Okay, he wanted to make it very, very clear. If he didn't say that, then somebody could probably appeal this and try to get the axe thrown out based on a ruling like this. Okay. So overall, due diligence. Burden of proof is on us in our private capacity to make sure we do in our contracts properly. Okay. When we do that, does legislation apply? No.
No.
Any questions?
So that would go to having a private club where you watch cockfights and illegal activities like that.
I can't comment on whether that would be legal or not, because you are harming animals, cruelty to animals now, right? Yes.
As soon as you use the word legal, you're going into statute.
Yeah. Yeah, you have to use the word lawful.
Then you've already defined it.
There's a huge difference between legal and lawful. There's a huge difference between public and private. Okay, what you do in the private is lawful as long as you're not breaking whatever law forms that you're operating under. Okay, so I got to make sure that I don't harm anybody. Love my brother as myself, which means I'm not going to kill anybody or steal from them or covet from them or anything like that.
And if you're operating under universal laws, you're not going to be fighting animals.
Right, because you're a part of nature and you're going to respect nature too, right?
So could we just appoint our own private judge that would, like somebody that would be wise among us, that would be able to judge? There are times when, you know, we need somebody, a third eye to look at the deal and say, well, this is right, this is wrong.
Yeah, if you're entering into your own private agreements, you can, part of that agreement is come up with a dispute resolution process where you both agree within that agreement that you would go to a third party to resolve any disputes. Okay, you can put that right into your agreement. Okay, we had an opportunity to listen to Sam Kennedy on the weekend, and you know, we can talk about this later on tonight too. But what Sam Kennedy is trying to do is trying to get grand juries set up for every state of the union to challenge and take over the authority of the corporations in the United States and put a moratorium on the banks foreclosing on property and tax cases and all that kind of stuff.
Congressional that they had the...
No, this is very different. No. But that's all based on the ultimate authority of the Lord and holding the grand juries sovereigns of the land, because who has authority over the sovereigns? God, right? So the sovereigns then have authority over the man-made institutions, which is governments and corporations and that kind of stuff, and actually take the authority from the corporations, because the corporations just usurped everybody's authority. Yes?
So I got confused a little bit with you know, the Declaration of Independence and all that thing, talking about the people. So the people definition in the United States is different than what the people in Canada.
Right, because we don't have a declaration. That's why I took their declaration, reworded it, and used it. Okay? So that I can get out from underneath the Queen as a subject and become my own sovereign. So that my authority comes from God rather than the Queen and her minions.
But we can still declare an independence from the oppression that we are suffering under via the banking cartel.
Right.
And their control over our governments and our courts. Oh, sorry. I was just,
She was standing up.
It's gone.
What Muriel's saying is, let me kind of sum it
Yeah,
up.
we can declare independence in a way from the control that we are under from the banking cartel's control of governments, courts, and other aspects of our life, because that's what we are suffering under right now. Oppression.
And they assume all that authority over us until we rebut the presumption.
Rebut it. So by declaring an independence from it, we are rebutting that presumption.
Right. Yes.
I'm just curious, you were saying your law was the Holy Bible?
The law form that I chose was Matthew 22.
Okay.
Okay.
Now, can people go as far as saying, I'm a Buddhist, I'm a Muslim, I'm a Baha'i?
Pick your law form.
Really?
If you believe in Buddhism and that's what you want to govern your life under, then that's the law form you govern your life under.
Does it have to be major religions, or can it be any?
It's private law, it's up to you.
It's up to you, like whatever you believe in. Am I in a position to dictate what law form you follow? No. Because if I do that, if I dictate the law form that you want to follow, then I'm just pushing my will against you, and I'm just harmed you.
I'm just wondering how that works exactly. You chose the law, I'm not sure, because before they swear people in on the Bible in courts in Canada.
Because in Canada recognizes the supremacy of God. It's all based off the Holy Bible. Because we come from Great Britain, and Great Britain is all based on this book.
A lot of the people in this movement have actually said that the Bible is probably the best commercial document ever written.
Yeah.
It's the basis of all true good.
And when the Queen swore her coronation oath, it was on this 1611 version of the Bible.
And to defend it.
And she swore to defend the faith. Okay. So when you look at other Bibles, like say Niv or the New King James, the words all change.
Yeah.
So you have to be really careful even interpreting this one. I looked up the word witchcraft in this Bible. Do you know what the word witchcraft is in Greek? Pharmacia.
Pharmacia.
Yeah.
Okay. So the pharmacists and the drug companies and all that kind of stuff are actually involved in witchcraft. Okay.
And pharmacy is also.
Yes.
Dale, all you have to do is get hold of the law, the Canadian Law Dictionary over there, look up law, and it'll give you the 10 definitions of law, and the first one is God's will. So use the dictionary whenever you're in questions. Just look up the word law in there.
Yeah, if you have any questions about how all this stuff works, I cover all of this in my modules. So if you want to start studying this stuff and actually figuring out how their game works and how to deconstruct all this stuff, come and talk to me afterwards, and we can start you on that education process.
I don't want to take up too much of your time on that one question, but thank you for answering.
You're welcome. Any other questions?
Justice.
Okay, well, thanks for coming out and deal.
So in a general sense, what's the application of this case to the average member of this little society here?
What's the application?
In a general sense, what's the application? What can someone take away from this? Just in a summary.
To summarize, essentially what I'm trying to get at going through this is that if you govern yourself and write your contracts properly, then and make sure that you have full disclosure, you do your due diligence, have consideration of both parties, there's absolutely no way any third party ever can interfere in that contract, including courts, lawyers, the state, police, anybody. It's called privity of contract, and that is extremely powerful if you do it properly and you do it in the private.
How it's called again?
Privity of contract.
Privity?
Privy.
Oh, privy, okay.
Yes.
To get away from what you're doing over here, you did say that you would, throw a little bit of light on as to what Sam Kennedy was said. You do that?
Sure. What Sam Kennedy is trying to do is, he had a broadcast on Sunday. We sent out a link to the broadcast, so if you guys want to listen to
How
it.
many people actually listen to those broadcasts?
Few people.
Time to do it.
Okay.
No,
Essentially what he's getting at is he's been involved with a group of people and they developed a process. And what they're trying to do is they're trying to establish a grand jury.
They're trying to reestablish the de jure government on the land.
On the land, okay? That's what a grand
On
jury
the
is all
continent.
about. Because the corporations have taken over in the United States, corporations have taken over Canada, corporations have essentially taken over the whole entire world. With this grand jury, they have the support of some elements of the military in the United States. The military actually approached him and said, if you guys do this, we will support you.
Oh, that's what it is.
And what it is a plan to regain control
Of-
the military came to them.
Of the Constitution of the United States. So they're trying to set up a grand jury in every state of the Union. And, just a second, and when they do that, they're then going to remove the corporate's authority. They're going to put a moratorium on mortgage foreclosures, court cases involving tax issues in the courts, and any of that kind of stuff, because all the bank stuff is all fraudulent anyway. And they're going to then start issuing sovereignty ID, like actual ID for man rather than corporations, and slowly start changing the infrastructure and the agencies and that kind of stuff to be properly serving the man rather than serving the bankers.
In a way that does not disturb the sleeping public.
Right. It will actually happen over time so that, well, we don't want to harm most people that are still asleep.
And they're so dependent.
They're vulnerable.
They're so incredibly dependent and vulnerable.
Because
we
I'm,
don't want to bring that harm.
because he's looking for sovereigns like myself and other sovereigns. And do we not have the same duty that the Queen does to protect the vulnerable?
Absolutely.
Absolutely. I have a duty to make sure I don't harm anybody when we're doing this. So it would be completely irresponsible for me to go and overthrow the government and throw everybody out in the street and they're wondering what in the hell just happened. Okay? So part of this process is to try to get control back into the hands of the people rather than the corporations.
The difference between them, Queen, and supposedly protect us is we, well, at least I assume that, we try to create something that would not harm anybody, in opposition to them who harm a lot of people.
They hurt a lot of people. Yeah.
Yeah, can I just go back? You mentioned full disclosure, due diligence. What was the third?
Oh, you're testing my memory now.
Consideration. Consideration on both
Consideration.
parties.
Yeah, contract consideration. Yes.
What I like about Kennedy's plan is he's talking about not just usurping them from a de jure method, but also from a commercial method, recognizing that these are commercial corporations. It sounds like they're going to be using bonds to basically negate the bonds that are in place, so that the commercial institutions then, all of a sudden, they have no surety for their operations. They're not covered, so therefore they will be scared to operate.
Yeah, that's good.
And
We
if
actually
they choose to join or choose to start operating in the de jure, the Sam and his people are essentially saying, we'll even give them credit for bringing about this wonderful change.
Well, that's right, if they're prepared to turn and prepared to
Yeah.
operate.
Yeah, because they can still keep their jobs if they're prepared to take on a new master. Instead of the CEO running the world, it will be the people running the world.
And he suggests that there's actually a lot of them waiting for this to happen.
Yeah.
Well, there's the law keepers, there's the law keepers group.
Oath keepers, see that? Yeah.
Okay. And we started seeing some of the documents that he's handing out, and ironically, it fits. I'm actually familiar with some of the processes because I use one of the process in regards to the title deed for the land that we're on when I'm trying to deconstruct the property taxes out where we are. So I'm very familiar with some of the technology that they're trying to use, which really excites me.
Is Ron Paul on board with that new US thing?
I don't know.
But he included him in the people that he,
Yeah.
yeah, he gives credit to, so there's a good chance
Yeah.
he's on board with this.
There's also quite a few states that have taken the initial steps to ensure that this is gonna be able to.
There's a lot of change going on right now. A lot of people don't see it, because all you see in the media is all the doom and gloom, but there's actually a lot of real positive, exciting changes happening, and it's gonna start accelerating.
A few of the states have started resolving to enforce the Constitution and the Declaration of Independence, which it doesn't seem like much, but really what it's saying is the federal government and the banks will not have the power there.
Their time is numbered.
Yeah. Is that because now they're so bankrupt?
Well, 47 out of the 50 states are now officially bankrupt.
Right.
Officially.
And they had a 2 million man tea party in
And-
Washington DC that wasn't on the news, that nobody heard about.
And at the same time,
2 million
Obama is trying to create Federal Reserve as a sole jurisdiction for not only money, but much completely aspect of operation, of any commercial operation.
That's right. Yep.
And that's horrible.
Has anybody else here read that the World Monetary Fund has been printing its own money?
Right, absolutely
Know the
right.
ramifications of that?
Yeah. Different money simply.
Well,
The
that would
special
be
drawing
the
rights?
international currency. They're trying to have one currency, one world government, one world
Yeah,
religion,
and
all that kind of stuff.
NWO, yeah.
Yes.
Have you registered your deed?
My deed?
Yeah.
No way.
No, like, I know that at one point in time you were gonna go down and.
No, I was going to record it.
Record it, that's
with
right.
land titles, but there's absolutely no way I'll register it.
Right.
Because
Is it-
registering it turns it over to the
Right.
crown,
Is it
right?
recorded at land
It's
titles?
not recorded in land titles yet, no.
If you register, you lose the jurisdiction.
How about if you record it?
If I record it, then I maintain, because I'm just recording a copy, I'm not actually giving them original, I keep the copy in my
You keep the
registry.
original
It's
in
just
yours.
a notice.
This is my registry.
Right.
Just like what this was used for hundreds of years. This recorded births, deaths, marriages, property, all that kind of stuff. And then just recently, it was usurped by the registry, land titles, vital statistics, all that kind of stuff. And essentially, when you register a birth or a marriage or property, you're turning over that property to the crown, and it becomes public.
That's a notice, you're recording it as a notice.
Is a notice, not a registry to them. Yeah.
What would you do about passports? A passport situation?
Well, that's another subject, but my understanding, I haven't actually tested this, so this is just hearsay, but my understanding is that if you post your own bond and have full disclosure to the jurisdictions that you're traveling with and have your private agreements, then you should be able to travel from point A to point B. Because when you go across a border, that's not a private interaction. That is a commercial transaction to facilitate the movement of your straw man moving from one corporation to another. That's all a border is. But if the man is actually traveling from point A to point B, just give private notice to the jurisdictions that you're traveling through, and you should be able to get there and back,
As any sovereign would.
as any sovereign would.
But you haven't tested it, right?
No.
Has anybody?
I've heard of people doing it. Yeah.
I don't know that this is a little off topic, but I just went to Winnipeg and back, and 6 times you have to produce photo ID.
Oh, yeah.
6 times, 3 times in Edmonton, 3 times in Winnipeg.
Flying.
Oh, yeah.
Flying,
Yeah.
right,
That's
okay? And 6 times I presented my ecclesiastical card. Once I got asked if it was government issue, and what I did then is I had my driver's license with me anyway, so I flashed my driver's license and took it away, and she said, "Have a good flight."
Oh.
So you used to.
So 5 out of 5, 6 times, that's what they want to say.
5 times they didn't even question.
See, I have my own government issued ID, okay? Because I'm self-governing, I can make my own ID, so I made my own. Well, I'm the authority, right?
But that's a commercial place.
independent sovereign individual, and it has me in my location.
They ask for government issue that you,
Back here,
if you have your own government.
They're in that picture.
Yeah, I probably needed a haircut back then.
Have you had to deal with being stopped by the police and not having a driver's license?
Yeah, I went to court.
You did.
Yep. And I beat it. Because I know who I am.
And you just said nothing to the police?
Well, I got to the, no, I didn't know better back then, so I testified to the police. But I started learning through the process to the point where, because I know who I was, when I stood up in front of the judge, I didn't have to say a word. All I said is, "Good morning, Your Honor," and she said, "Case dismissed." I didn't have to argue nothing.
I've talked to several people who've been stopped by the police, and it's a matter of being prepared and pre-notice.
I had to do my due diligence. I rebutted.
Those who believe they're in authority in the areas you're going to, and when they stop you, you present the paperwork, copies of your paperwork, and they're usually quite happy to let you go on your way.
But I've done my due diligence. I sent letters to the Solicitor General and Attorney General. You know, because when you get the notice in the mail to renew your driver's license, that's an offer to contract. So I rebutted their presumption. I sent a letter to them, and I sent my declaration. I sent my fee schedules and all that kind of stuff. And then when I got stopped, I fired letters to the police officer and the lawyers and the Crown. I asked for full disclosure, and I knew what to say to the Crown prosecutor before court started. Okay. And because the Crown prosecutor is part of the court, so if I agree to be that person, I've just given them jurisdiction, even though the judge hasn't even walked in yet. I didn't give them that. And so when the court started, they had absolutely nothing on me. They had to dismiss it.
But now you wouldn't even have to go to court, because you would deal with it in.
The only way they're going to get me into court is they have to come and physically drag me into court now. Because I know that their court is de facto and it doesn't apply to me whatsoever. Doesn't apply any to you guys either, but we all walk in there like lemmings. Okay, anything else? Thanks, guys. Oh, yeah.
That's okay. So you drive without a license plate?
I don't drive.
Yeah.
Driving is a commercial activity. I travel under my private capacity to travel. When you're driving, you're in the public because that's a commercial activity. It's all about the words they use. Okay.
So what is it that you do instead of driving?
I travel.
You travel. Under what means? Yes.
I travel using my 1994 Chevy Half-Ton.
Without a license?
Why do I need a license?
Exactly.
Because it's private. We just went through this whole thing.
And no plates, eh?
You're coming in about, 19.
Is Sam's whole premise and everything, because in their discussion, he mentions about a North American activity, although it is.
He talks about world activity.
And world activity,
Yeah.
and so how does that applying here in Canada, or how
Okay,
are you guys
well,
taking that to range?
what I'm doing is I'm in communication with a small handful of people, and we answered the call. Because in my personal opinion, this is a fantastic opportunity to actually do something when we have so much momentum. So I'm looking for sovereigns who are willing to participate so that we can try to do something here in Alberta.
We need at least 26.
And we need at least 26 sovereigns to do it.
Why 26?
Because 26 is how many people you need for a grand jury.
Oh, you never read that grand jury definition?
I didn't, but we're running out of time here. So if anybody out there, any sovereigns out there wanting to participate, now's the time.
And look up the definition of grand jury. Google it.
Yeah.
Come up on Wikipedia and read it, learn it,
Okay.
understand.
There's a question here first.
I mean, I'm one of the 26.
Okay. If there's sovereigns out there that want to participate, email me. My email address, rpage.np as in Nancy Peter @gmail.com.
It's also in the list.
rpage.np as in Nancy Peter @gmail.com.
Is it Nancy Peter?